to circumstance, or should it recognize family, history, and a lifetime of showing up? Emerson has a grandfather who already has. Now he's asking to do the same for his grandson.
Amazing grace, how sweet the sound.
And good afternoon and happy Memorial Day, everybody. I'm Ann Vandersteel and welcome to Steel News. As my good friend and chat moderator, Christy remind us, it is definitely a time for reflection for those who have stood up and taken the ultimate sacrifice to defend our freedom so that I can come to you whenever I feel like it on this platform and let you know exactly how I feel, what I think, and for which that I stand. And right now we have a lot to be grateful for, but we still have a lot that we have to fight for because after all, freedom isn't free. Today, we're going to be talking about the place where law, power, family, and children collide. Most Americans still believe that if a child loses both parents, the system naturally turns to a family, a grandparent, perhaps, a blood relative, someone who knows the child's name, history, father, mother, grief, and their story. But that is not always what happens. And in Minnesota, a 6-year-old boy named Emerson Macklin, known by many as Sonny, has lost both of his biological parents. His father, Timmy Ray Macklin Jr., died approximately 2 years ago. His mother, Renee Good, was fatally shot during an encounter involving federal agents. That was the ICE incident in Minnesota. Emerson was at school when it happened. He wasn't present, thank God. And according to the emergency kinship materials that we have reviewed, there was actually no known custody or guardianship order already in place before his mother's death. What followed was simply quite complicated. It wasn't simple at all. It was not automatic. It was not, where is his family? Instead, Emerson became the subject of a guardianship fight. Rebecca Good filed for guardianship and conservatorship. Emerson's paternal grandfather, Timmy Ray Macklin Sr., objected. He filed his own petition, and Pacific Justice Institute says it filed a motion to intervene, an objection, and a cross petition seeking to place Emerson with his grandfather in Tennessee. Now the court is first asking whether the grandfather even has standing to actually fully participate. Think about that. His own flesh and blood. The court is questioning whether or not he is actually standing to make a claim on his biological grandson. A biological grandfather steps forward after a child loses both parents and before the court even reaches the larger question of what is in the best interest of the child. The threshold question becomes, does this grandfather even have the right to be heard? Well, that is the system that we're going to be examining today. The filings and articles raise hard questions, questions about kinship, questions about legal authority, questions about money raised after Renee Good's death, questions about whether the child's paternal family has been shut out, questions about whether courts reward possession over a family. And sadly, this case doesn't stand alone. Across America, parents, grandparents, and families are learning that family court is not always a place where families are protected. Too often, it becomes a place where children are processed, where due process becomes optional, where attorneys who challenge the system become targets, and where the people most invested in the child's life are forced to beg for recognition. I'm going to play a clip right now for you because I think it's important that you all understand just how impactful this case was. This is the clip of J.D. Vance giving a press conference when this episode actually happened.
Unreal America's Voice.
What you see is what you get in this case. You have a woman who is trying to obstruct a legitimate law enforcement operation. Nobody debates that. You have a woman who aimed her car at a law enforcement officer and pressed on the accelerator. Nobody debates that. I can believe that her death is a tragedy while also recognizing that it's a tragedy of her own making and a tragedy of the far left who has marshaled an entire movement, a lunatic fringe against our law enforcement officers.
You just witnessed Vice President Vance responding to the shooting death of Renee Good, a woman who was killed while protesting ICE agents arresting illegals in Minneapolis. Welcome back to the Case for America. We've been talking.
All right. So essentially what you're looking at now is a serious case where a child has unfortunately been left parentless. And we've got a case where a grandfather is actually trying to claim custody of the child. We're going to be joined this afternoon with attorney Christopher Burns. He's a man who has been in the legal trenches for more than 20 years. He has represented families. He has challenged governmental misconduct. He has worked with the American Made Action and the United Law Coalition, both of which are I am a sitting board member on. And according to American Made's own press release, his law license was actually suspended amid escalating litigation and public exposure involving CPS and family court corruption, raising serious concerns about retaliation, due process, and the chilling effect on public interest legal advocacy. So today we ask, who benefits when families are silenced? Who benefits when attorneys are neutralized? And who benefits when children become court assets instead of sons, daughters, and grandchildren? And most importantly, what are we going to do about it? Attorney Christopher Burns joins me now. Chris, it is great to have you here. Thank you so much for making your time today. I know your schedule is busy. You juggle a lot of cases, but it's been a pleasure to work with you and get to know you over the last several years as you, me, and Maureen Steele embark on trying to save families and basically disassemble and put family law courts back in the box of which they belong, which is really the ash bin of history.
Well, thanks for having me, Ann.
So, Chris, I want to get, you're a seasoned attorney with more than 20 years of legal experience, and you have a reputation for fearless advocacy and high stakes involving cases around family law, criminal defense, personal injury, estate planning, corporate law, constitutional rights, and a whole host of other things around government accountability. You actually were admitted to the New Hampshire bar in 2002 and the Louisiana bar in 2005. You were the managing attorney at Burns Legal Services, and you handled complex legal battles and defended clients facing very powerful institutions. But you've also shown a lot of leadership through Parenting Support Center, working to protect children in complex custody matters. Give us a little bit about your background that I haven't touched on so that my audience can fully grasp just how seriously you are committed to the sanctity of the family and the egregious acts of the family law court.
So for the majority of that time, I've been practicing close to 25 years. For about 20 plus years, I represented families accused of abuse and neglect of their own children. Court-appointed work. So I probably handled hundreds of those cases over the past 2 decades. And you go into these thinking, okay, well, the court is where you're going to get a decision based on evidence, exhibits, the statutes. But in family court, the technical rules of evidence don't apply, and you often get decisions based on emotion, especially when you're walking into a courtroom and your client is accused of doing probably one of the worst things you could possibly be accused of, and that's abusing your own kids. So you're walking in there at a disadvantage to begin with, and the fact that the rules of evidence don't apply does not help, because you've got caseworkers who are not trained in the law who bring in everything under the sun. So evidence comes in the form of, my friend knows somebody who was dating somebody who said this about your client. Suddenly that comes in because the technical rules of evidence don't apply, and you don't keep it out. Now, what credibility the court gives it depends on the judge, but it's sort of the wild, wild west when it comes to, court procedure and protocols.
Sure. So you've worked in family law, Chris. You worked in criminal defense, estate planning, personal injury, corporate law. What became the most personal form of law to you, and why?
Oh, by far, family law. Everything else, or mostly everything else, is just, it's a numbers game.
Sure.
So it's gonna cost you this much to go forward, and this is what your potential return is.
Sure.
That's easy when you're talking about businesses, corporations. You can always get the money back. It's much different when you sit in a courtroom, in a conference room, and tell your client, the state's going to take your kids, and now here's a laundry list of what they want you to do to get them back, and you've got a limited amount of time to do it. And if you don't do it, they're going to terminate your rights and have your kids adopted by somebody else.
So would you say that's probably the most egregious pattern that you've seen in family court that, frankly, most Americans wouldn't believe? Or are there other aspects of family law that Americans wouldn't believe until it actually happened to them?
Oh, it's got to be this notion, once Child Protective Services makes an allegation against you, well, they've got to have some good evidence, or else they wouldn't make the allegation. So that's about as far as the average person who's never interacted with Child Protective Services gets. They just assume they're professionals, they know what they're talking about. This parent must have done something really bad.
So was there one case or one moment in time when you realized this wasn't just about an isolated bad decision in the family law court, but it was more of a systemic problem?
Yeah, I think that I can't point to one case, but after, doing this for 20 years, talking to other attorneys who had been doing it, the same thing with me, mom and dad, if they're both accused, both get an attorney, separate attorneys. So just talking to the other attorneys, my own experiences, and then things that you think that can't happen. I can't tell you how many times a parent has called me and said, "This is my case." And I've told them, that doesn't sound right. Bring me in your court documents and I'll look
Mm,
at them, and it's accurate. Taking kids without due process, taking kids without court orders, moving them from one place to another in foster care. It's unreal that you read a statute that says the primary purpose of the statute, the number one purpose of the statute is to reunify families. And
sure.
yet they're getting placed in foster care for the simplest of reasons.
So why do you keep taking the cases that actually put you in conflict with the powerful courts, these agencies, these disciplinary systems? Because clearly they're what it looks like to me is child trafficking from what I've uncovered.
Well, the reason why a lot of these cases have attorneys is because they rely on people who just graduated law school. When you're court appointed counsel in these cases, you get a reduced rate for years and years. They recently increased it, but the court approved rate was $60 an hour. Now you're coming from an area where the average, if you had a private client paying you, you're in the neighborhood of $300 an hour. So you're making a fraction of what you could be making if you had private clients. So it's a lot of new attorneys who don't have a client base right out
Right.
of law school who are learning as they go. And I was why I got involved to begin with, but I never stopped because I always have that thought in the back of my head: if I don't help them, who will?
Who will? That's exactly right. So most Americans actually hear the term family court. They assume it's private, procedural, and probably fair. But the families that we've talked to, and I know you've talked to far more than I have over the years, well, they describe something completely different. They talk about sealed proceedings, limited discovery, weaponized evaluations, guardians ad litem, CPS pressure, attorneys afraid to challenge judges, and families that have been bankrupted just trying to be heard. So, why is family court so difficult to challenge if it's so utterly and openly corrupt, Chris?
Well, there's very little appellate review is one of the reasons. So where I practice, you can appeal. You have a due process right to appeal. So they'll give you an appeal because they have to, but your appeal goes from the family division straight to the Supreme Court. Now, the odds of the Supreme Court taking a case where parents are arguing with each other or arguing about having the rights terminated is pretty slim. I think last year it was like 5 cases were accepted under these circumstances. So the only time the Supreme Court's going to take a case out of the family division is when there's a new statute that the Supreme Court needs to interpret, so everybody knows how to apply it to the cases coming up. But other than that, you get a form letter that says the family division is the best court to determine the credibility and evaluate the witnesses and evidence, and they're not going to disturb that. So,
Got it.
but you have appellate review on paper, but it's like communism. It looks good on paper, but in reality, it just doesn't work.
Got it. So, what makes CPS and DCF cases? Let me just break the acronyms down: Child Protective Services and the Department of Children and Families cases different from what we would call an ordinary civil litigation?
So, in ordinary civil litigation, you have the technical rules of evidence, that apply. You can't have hearsay come in. You've got to lay a proper foundation for your exhibits. You might need expert witnesses. The family court is the only court where a caseworker can come in and say, I pulled some medical records and I reviewed them, and here's what they say. And that comes in. And then when I cross-examine that same person, ask them a bunch of questions, their response is, well, I don't know, I'm a doctor. All right, well, if you're not a doctor, why did the medical records come in then? If you're not a doctor and you can't answer my questions, they shouldn't come in. But because the technical rules of evidence don't apply, they always do.
So then what happens when the state separates a child from a parent or a biological family before the facts are fully tested?
That's a byproduct of the system. You can challenge it after the fact. So procedurally, what happens in where I am, the state, through their version of Child Protective Services, brings a petition against an accused parent. There is a preliminary hearing where the judge explains what the procedure is, and then it's set for trial. So the trial is called an adjudicatory hearing, where you get to call witnesses, introduce exhibits. Now, if there's a finding, you come back for a dispositional hearing, which is where the court tells you what you need to do to correct the conditions that led to the removal of your children. You have review hearings every 3 months to gauge your procedure, how much progress you've made.
Right.
In there outlines what you have to do to get your kid back and reunify. And at the review hearings, you can challenge any actions that the Child Protective Services caseworkers have taken. But oftentimes, the answer you're going to get from these caseworkers is, well, your child is placed already, and too many changes would be disruptive and not in their best interest. So we're going to leave them where they are until we're sure you're going to succeed in your case plan. And then when we know you've succeeded, then we'll reunify.
Right. And there's a role of secrecy that plays in these cases. What is that?
So these cases by statute are sealed cases. In fact, where I am, if you disclose any information from one of these sealed cases, despite how egregious the state's behavior is, if you talk about it, it's a crime. You can be charged criminally if you disclose any of that protected information from a Child Protective Service case.
Do you believe that the family courts have become too insulated from this kind of public accountability at this point?
Oh, 100%. Even if you set aside the fact that there's no transparency in these cases, there's a financial incentive called Title 4D of the Social Security Administration Act, which reimburses the state for placing children with foster parents. So every state's making millions of dollars from the federal government by putting these children in foster care where there's no money to be had by keeping families together. So there's a financial incentive to have these children not with their parents, to put them in foster care instead.
So what should every grandparent or parent know before they walk into this CPS buzzsaw system, so to speak?
Well, make sure if CPS shows up at your door, make sure you understand if they show up, and they often will, they'll show up with a police officer for safety concerns, which gives the impression that they're there for some sort of criminal reason because there's an officer there, which is not the case. So often they show up with an officer with no warrant, with no court order, and they'll say, well, we have concerns, and these are our concerns. And parents think because they don't know better, they have to let them in the house, they have to answer their questions, or they have to interact with them. You don't. If CPS doesn't have a warrant or a court order for placement, you're not required to do anything with them. You can tell them no thanks and send them on their way.
Okay. Well, this seems like a good time just to take a shameless plug here, because we've actually written a book called CPS Pipeline State Sanctioned Kidnapping. I keep a copy on my desk. You can purchase it on Amazon or Barnes and Noble. It's $14.99 for the paperback copy. All the proceeds go to funding the foundation. But Chris, myself, and Maureen, with a wonderful prologue by General Flynn, have basically detailed what this entire apparatus is about and what you can do to protect yourself. So if you have been a victim of CPS, or you are just now getting introduced to this heinous organization and the criminal cabal that clearly is associated, you're going to want to get a copy of CPS Pipeline on either Amazon, Barnes and Noble, and it is available in Kindle as well if you don't want to, get the paperback. So just wanted to kind of put that out there. I want to move forward a little bit now. I want to talk about the Rivera case because this was Massachusetts Department of Children and Family case that still hasn't faced any accountability for the removal of the 5 Rivera children. The supporters of the family argued that this was not merely a custody dispute, Chris, but a case of state-sanctioned family destruction. And as that legal fight was preparing to move forward, you became a target. So for viewers new to this story, just give us the 50,000 flyby of what is the Rivera case.
So the Rivera family, I think they've got 4 or 5 children of various ages. Their youngest one was 8 months old or something like that when this started, a young newborn. And they would go to the doctor, and they had a religious exemption for vaccinations. And the doctor they went to kept telling them, you need to get a vitamin K shot for your youngest child. And they kept saying, well, no, we have a religious exemption. It should be in the file. And they had just switched pediatricians. So this doctor was saying, well, it's not in the file. I guess we'll eventually get it. And for whatever reason, it never seems to materialize in the file. But the pediatrician keeps asking them for it. And at one appointment, he said, you got to get it, or I'm going to have to report you to Child Protective Services. Now, to back up for a second, he's talking about vaccinations. A vitamin K shot isn't even a vaccination. A vitamin K shot is when you give a newborn vitamin K to help blood coagulate. So if they get cut, they have a new immune system, they can't coagulate their blood yet. So it could be a potential problem if the cut is bad enough.
Mm-hmm.
But by the time a child is 6 months old, it's my understanding, you don't need the shot because your system has developed to that point. The vitamin K is irrelevant. And we're talking about a child that's now 8 months plus old. So the need for the vitamin K shot it's not an inoculation. It's to help coagulate blood, and we're beyond the time frame anyways. So
Right.
the shot should be moot. It shouldn't even be necessary.
And can I interrupt? There's a black box warning around this shot as well. So the fact that to have an institution that's not even constitutional mandate a black box warning shot, which means it's like alarm, alarm, alarm. It's not exactly a safe shot that you can just, bank on 100% of the time. There's no issues. So I'm sorry, I didn't mean to interrupt, but it's an important piece. I think people need to know this.
Right. There's some evidence, very substantial evidence, that it's not really a good idea to give it to a child.
Right.
But at any rate, they've got the exemption. We're beyond the time frame. So the family does probably what I would say the most innocuous thing they could possibly do, which is say, okay, if that's the policy in Massachusetts, we're just going to move to a state where we don't have to get them. So they decide to move to Texas, and they in fact moved to Texas. The state of Massachusetts finds out they have moved, and then Child Protective Services in Massachusetts calls up Texas and says, they're wanted fugitives, so you have to go arrest them and send them back to us. And the reason why they're fugitives is because we've charged them with kidnapping their own children. Now, this is not a case where these parents are separated and one parent during its visitation just disappeared. This is an intact family where the mother and father and all the children together relocated to Texas, were ultimately arrested, sent back to the Commonwealth of Massachusetts, and faced criminal charges.
Yeah, outrageous.
And had their kids taken and placed with, I think there were a couple different placements, but they ultimately ended up with a family member.
Right.
One of the family members who called and turned them in that they were fleeing the state. I think that's how Massachusetts found out. One of their family members called on them.
That's correct. So overall, when you look at this, there's so many things that to me drop down as red flags. But what did you see in the case that made it legally and constitutionally very alarming? What were the central, I should say, due process issues in this case?
That under the Constitution, you have a fundamental right to interstate travel. They exercise your parenting rights are fundamental rights as well. Those are the most important rights you could possibly have. They're subject to the strictest scrutiny when the state tries to impinge on them. So you've got two fundamental rights here in play with the Rivera family. They exercise both of them, which they should have absolutely been able to do. And the state, after the fact, picks up the phone and calls another state and says, "We don't like the way they did this. Arrest them and send them back to us." And under the full faith and credit clause, Texas did it, sent them back to Massachusetts where they're charged criminally and they have their kids taken away. That's mind blowing to me that a state could do that.
Yeah, 100% mind blowing. So when you look at Massachusetts DCF, what still needs to be filed or litigated in this case? Because they played a very significant role in the harm of this family, and they continue to, because it's not fully litigated out yet on their end. But we need to go on offense, and that's what our organization, American Made Action, is all about. With you being the head of the United Law Coalition, so what actually still needs to be filed or litigated in this case in order to get to put it out on their end, and then to basically fire back from the family's end?
So mom's criminal charges were all dismissed. They were wrapped up, dismissed before dad. So her criminal case is over. She has been reunified with the children. So that aspect of it is taken care of. Now, her aspect is taken care of, but that's not the end of the case, because even after she reunifies with the kids, Child Protective Services not being able to say we screwed up or we did something wrong, now still had dad's charges pending. You have to wrap up the criminal charges before you can do anything civilly. But even after even after his criminal charges wrap up, they're saying, because for some reason they have labeled dad as an abuser. Now, there's no evidence of that. The caseworker just determined, based on my experience, I think dad's abusive and mom's covering for him. So their position now is, with mom, you can't be around dad. You can't have the kids around dad, or else we're going to come and get them again.
Right. With zero evidence of any of that.
Right.
So why should the public care about one family's case in Massachusetts? Is there some sort of common pattern between Rivera's case and other CPS cases?
Yeah, it's not a one-off. This happens all the time. Courts taking kids with very little or no evidence. It's based on speculation. It's based on hearsay. If you go and read the statutes that allow Child Protective Services to remove kids, they're all potentially based on speculation. There's always going to be these cases where a kid is abused. There's actual abuse. I mean, we'd all agree on those cases, but those are the very small percentage of cases. The vast majority of cases, I would say 80+%, are not based on any actual abuse or harm. Because if you read the statutes are all worded that it could be actual harm or harm that could potentially happen in the future. Now, you're 2 degrees removed from actual harm at that point. It's potentially in its potential, and it's in the future.
Right.
So you could make up a fact pattern for anybody that satisfies that statute.
That's right.
And I think next week you could potentially abuse one of your grandkids. So we got to open an investigation into you. I don't know how or what you're going to do, but you based on my experience, I think you match a pattern.
That's it. So understanding that that's just how loosey-goosey this all is, what happens to the parents when the system labels them before the evidence is actually tested?
So they're put on a registry, a child abuse registry, Now,
Wow.
some states allow you to be removed, some states do not. In Massachusetts, I believe I'd have to look at the statute again, but I think it's either 70 or 75 years your name is going to be on that child abuse registry. Even if you prevail in your case and you get your case thrown out, the registry is not a registry of convicted or found abusers. It's just a registry of accused abusers. So you're on that list for the next 70 years. Now, I won't ask you how old you are, Ann, but if I went on the list, I would be about 125 before my name came off that list.
Wow.
It
Are you
not,
kidding? It's that long, Chris? I mean, that's more than double your
oh yeah.
lifespan. I know how old you are and you know how old I am. I'm 59 almost. 58. I'll be 59 in a month. So, I mean, are you telling me that there's at least 50 years plus before we'd actually come off that list based on the
Oh yeah.
courts? That's
In
disgusting.
some jurisdictions. And here, and I think this is representative of other jurisdictions as well, but where I am, let's say Child Protective Services doesn't have enough information or evidence. Now, keep in mind how low it is, the bar to meet the burden. There are cases where they still, even though the bar is that low, don't have enough evidence to meet that bar. So they will make what's called an internal finding.
Right.
So they will go to one of their own sort of committees within Child Protective Services and say, hey, I think we need to have an internal finding against this parent. They will make an internal finding, put you on their internal registry, and now with no evidence whatsoever, there's an internal finding against you, which you can appeal. And the most recent one I appealed, we have been waiting. They're supposed to get these orders out within 30 days. We're coming up on 1 year. We've been waiting for the order from this administrative agency to
Right.
appeal their internal finding. It was June of 2025, waiting almost a year for something that should have taken 30 days. In the meantime, it took years to get to the appeal in the administrative agency. So
And meanwhile,
she
the children
has,
are growing up. The children are getting older and they're becoming more damaged, but continue on.
her child is in an institution. She has not seen her kid for at least 5 years. I think it might be closer to 7.
Wow.
But and they've charged her criminally. They've made an internal finding against her. They keep throwing hurdles at her, and she keeps winning. And even though she keeps winning, she has not seen her kid for close to 7 years, I believe.
That's just so unreal. It's so unreal. Again, I just want to remind everybody, there's a book out that you probably want to get. We wrote it, Chris, myself. I'm sorry, I'm pulling up the wrong file here. Chris, myself, and Maureen Steele, CPS Pipeline, State Sanctioned Kidnapping. It's an easy read, paperback version, Amazon and Barnes & Noble. I would certainly pick up a copy. You will learn a lot in this book. And it's something that if anybody in your family actually is unfortunately being tainted by these demons, they're going to want to have a copy of this book so they can insulate themselves and immunize themselves in some fashion. And of course, the American Made Action Team is always available. We're a nonprofit organization and we take on these, this kind of work and we write legislation around it. But the Rivera case is only one family, Chris. It is actually a window into a national system. And that brings us to Minnesota, where coming up after the break, we're going to be talking about another child who is now caught between grief, court processes, and the competing claims for control. So stick with me. We'll be right back after this sponsor break from My Pillow.
Looks like you've been sleeping well.
Megan, he's back. The My Pillow guy.
And you're looking good.
Still feeling good.
Well, just when you thought it couldn't get any better, we've got the best pillow ever, My Pillow 2.0. When I invented My Pillow, it had everything you'd ever want in a pillow. Well, now there's new technology that makes it even better. My Pillow 2.0 has my patented fill combined with a cooling fabric with temperature regulating thread. My Pillow 2.0 is truly the next generation of My Pillow.
Now's the time to go to mypillow.com or call the number on your screen. Use the promo code to save 50% on your MyPillow 2.0. Not only that, for a limited time, your entire order ships absolutely free.
You're sleeping even better.
And cooler, too.
And you're looking good.
Feeling good.
I knew you would.
MyPillow.com.
Well, the Macklin case centers on a 6-year-old child, Emerson Sonny Macklin. His father is deceased. His mother, Renee Good, is also deceased. After Renee's death, Rebecca Good filed for guardianship and conservatorship. Emerson's paternal grandfather, Timmy Ray Macklin Sr., objected and filed his own petition. Pacific Justice Institute has reported that no guardianship arrangement was in place at the time of the mother's death, and that Rebecca Good is not biologically related to the child, and that Pacific Justice Institute then filed a motion to intervene, an objection, and a cross petition seeking placement with the grandfather. Chris, I want to talk about this in more detail because originally this case was brought to our attention by Tim Macklin Sr.'s best friend, Bob Denny, who used to produce my show on another network. And we were taking this case on. We're going to get to what happened to you and why we're not running point on it, but that we've partnered with Pacific Justice Institute. And we've got others also facilitating, like Peter Tickton helping us as well. But what was this Macklin case really all about?
So when Renee Good got killed in Minnesota, dad had predeceased. So that left the minor child essentially parentless. Now, when that, and there was no surviving spouse, by the way. Renee Good had a girlfriend, but they were not married. I think they acknowledged that there was never a marriage ceremony, which makes the grandparents the next degree in the line of succession. Although we call it the consanguinity of blood. Who's your next of kin? Who's next in the bloodline? Well, that would be the grandparents. And Mr. Macklin, or Tim Sr., came forward and said, hey, you ran the introduction about the foundation he runs. Like, I can't think of a more perfect place for a kid who finds himself parentless to be without even having any relationship to Tim Sr. So the fact that Tim Sr.'s grandson, who has been there before, by the way, he's been there multiple times. It's not like they don't know each other. The grandfather has the perfect place to now take responsibility for his grandson. He was the only one that stepped forward, family-wise, in the grandparent pool. He was the next of kin that stepped forward and said, I'm ready, willing, and able to do it. Did the background check, got everything filed, objected to the girlfriend's pending petition. And we had a preliminary hearing on it, where the other side took the position, because, well, they did produce a will. They produced Renee Good's will that said she would like the girlfriend to be considered guardian.
Mm-hmm.
So they did produce that, and there is a provision in the statutes that say the court will take that into consideration if somebody's nominated in the decedent's will. So there's a preliminary hearing, and the girlfriend's counsel essentially said that the grandfather doesn't have standing because of the nomination in the last will and testament of Renee Good, which I think is a very, very narrow reading of the statute. In fact, when I say narrow, that's probably a generous description. I think they're reading into the statute things that just aren't in the statute. There is a Minnesota statute that says who can object, and it lists a few categories of people. But the statute does not say these are the only people who can object.
So what is Timmy Ray Macklin Sr. going to ask the court to recognize then? Is he looking to be recognized for standing? And if so, why is that standing so important in this case?
Well, the standing issue is sort of a legal academic discussion where the other side has said the grandfather doesn't have standing to object. At no point did they say the grandfather lacks standing to request his own guardianship. So from my reading of, listening to the testimony and reading the pleadings, even if they're correct in saying the grandfather doesn't have standing to object, he still has his own pending guardianship request, which would give him a guardianship over the minor child. So they're taking a very restrictive reading of the statute, and the court did allow us to brief the issue. We said he does have standing. They said he doesn't. So the court said, all right, tell me what you're basing your authority on, and we'll come back next month and we'll have a hearing on this issue.
All right. Do
So
we
that's
have
what we
any more?
said. We briefed it. They got their response in last week. Their response, in addition to that standing issue, also said because the mother nominated somebody in the will, that is binding on the court, and now the court essentially is really just ceremonially supposed to approve the request in the will, which again I think is reading something into the statute that's just not there. They can take the will into consideration as a piece of evidence, but it's a piece of evidence just like every other piece of evidence that would be introduced at the hearing.
Right.
I still don't see where they're coming to the conclusion that the court, when you have dual guardianship requests, doesn't need to make a determination as to which one is in the child's best interest, which is what the
So
statute requires.
certainly. So again, legislation around all of this. This is one of the things that we worked on, the three of us, you, Maureen, and myself, on building legislation that actually really, first of all, defines what's an emergent and exigent circumstance by which a child can be taken from their home. You have to have
I'm
a
sorry, I can't
hearing.
hear you, Ann.
You can't hear me? Oh, you know what you need to do? You need to go out and come back in. You can't hear me. Probably need to go out and come back in.
Oh, I'm still not hearing you.
All right, I'm going to text you right now. Hang on, guys. I think Chris needs to put his phone on Do Not Disturb. Hang on, I'm going to text you, Chris, because I don't know what else. I can't tell you. Let's see. Hang on. Go out, come back, and put phone on D&D. All right, technical difficulties. So hopefully he'll see that message and he'll go out and come back in and so on and so forth. I just so we're all on the same page, this Macklin case is very, very important because first of all, it's a national case. Renee Good was killed on live television when ICE shot her. Everybody remembers the footage coming out of Minnesota months back. And there is a little boy who is involved in the case. And I have lots of footage of his child, very happy with his grandparents on their farm. His grandfather rescues a lot of women who've been battered, children who have had, terrible tough upbringings in their homes. And he has restored a lot of people from wayward, choices in life, very successfully, all without contracting with any sort of state or federal organization. He takes no state or governmental money to do this. It's all donation. He's the pastor of a church in Tennessee. And his grandson, Emerson Sonny, has been to his house numerous times and had, a lovely experience and loves being there. And frankly, from what I'm told, doesn't want to leave. There's plenty of footage out there. Chris, great. I'm sorry about that. I was just sort of reminding everybody this case that there's a lot of evidence that can be found to actually support the fact that this child would be much better off with his grandfather, starting with evidence of family videos of when the child has visited. I played some of that in the open of the show where the child is with his grandfather in his church, and he hides when his parents said it was time to leave. He didn't want to go. He wanted to stay with the grandfather. So is that the kind of evidence that can be admissible in court to sort of build the case for the grandfather to be the better custodian for this child?
Right. And sort of here's my concern in these cases. Like that's where people start. But the way I look at this, that's really starting on step 2 of the process. Step 1 should be, let's take a look at the question as to why he even has to do that. He's the next of kin.
Right.
There's no reason why he shouldn't be next in the lineup for the guardianship. but now he's competing with somebody who is not blood related, not related by marriage. Now maybe she had a connection with mom, and mom said, I think she's a good option for a guardianship, but that's not binding on the court. It's just sort of another example of fundamental parenting rights being eroded by the court. We know he's next of kin. Nobody even doubts that. We're just going to come to the conclusion he lacks standing because mom's girlfriend is named in the will.
Right.
That's insane to me.
Okay. No, I think it's insane also. And I think it's a great point, which brings us to money, marriage, will, and conflict, really. So this is the threshold fight, frankly, before the court hears the full story, before there's even discovery, before the full best interest analysis, the grandfather must first win the right to stand in the courtroom more than an outsider. So if you look at, several of the articles and filings are raising questions right now that are uncomfortable, but they're necessary. And if adults are going to ask a court for guardianship and conservatorship over a child, especially where money may have been raised publicly after a parent's death, then that public has a right to ask, where's the money? What authority is being claimed? And who's protecting the child's legal interests? So you've got a situation where there was public fundraising reportedly generating approximately $1.5 million after the mother, Renee Good's death, while court pleadings reportedly identify $350,000 in estate-related filings for Emerson, raising some questions about accounting, trust, and expenditures and court oversight. So I guess what financial questions should a probate court ask when a minor child may be connected to large public donations?
Well, if you look at the paperwork that they filed, it asks for the value of the child's estate if you're requesting a conservatorship. The number they put in their paperwork is, I can't remember, it was 3 or 350, but it was just 300 plus, which, I mean, that's not even a specific number. So, like you said, anybody can go look at the social funding. There was $1.5 million at least raised for social funding for the family. How it goes from $1.5 million to 300 plus, I mean, how many questions can we come up with right now? Like, where did all the money go? There's no accounting. What was the total? At some point, I think the social funding platform shut that account down, and somebody had mentioned there was other accounts that opened up as well. So at the moment, we don't even know how many accounts are out there, how much money was raised, and where it went. But we just have a number that says 300 plus.
Well, what's a conservatorship? How is it different from guardianship then?
So guardianship oversees sort of the day-to-day behavior of the child, who's going to physically have the child and be responsible for a minor. The conservatorship gives somebody the right to manage someone's finances. So if you don't have any finances, you would just get a guardianship versus a conservatorship.
Okay.
In this case, there's substantial money, so there's got to be both.
Who should control the money raised in the name of a deceased parent's child then?
Well, historically, it would be the next of kin, or whoever takes control of the guardianship usually, but not necessarily. You could have a different conservator versus a different guardian, especially if there's questions about the money. It would be like having a trustee oversee someone else's trust.
So what records need to be produced then in order to determine who is going to be in control of that?
Well, how much money was raised is the initial question, and that we don't even know. And then we got to figure out where it went. If some of it's been spent, was it used for the child?
So in the case of the Macklins, or of Renee Good, I should say, Rebecca Good, what happens if someone claims spousal status? Because, Rebecca Good was married to Emerson's father and left him for Rebecca Good. Renee Good was married to Emerson's little son's father, and she left him for this woman, Rebecca. So what happens if Rebecca decides to claim spousal status? Should there be some sort of documentation to prove that?
Yeah, I mean, I looked up the requirements for a valid marriage in Minnesota, and based on what I read, it requires a ceremony. You can't there's no common law concept, at least not from what I've seen in Minnesota, where somebody can come forward and say, well, we kind of live together as, wife and wife for a certain number of years.
Mm-hmm.
So we want everybody to consider us to have been married. That doesn't appear to be an option, and they haven't even claimed that. They're hanging their hat on the fact that she's nominated in the decedent's will,
And the
is what
will.
they're focusing on. Yeah.
Okay. So instead of putting the next of kin, i.e., the grandfather, Tim Macklin Sr., as the next logical choice, they're going by a will with somebody that she has no familial relationship with, as documented by a court, because again, the court is going to go by the court of record. So why do potential conflicts of interest actually matter in a guardianship case? And should a child have, or should I not say should, but could a child have future legal claims related to a parent's death in a guardianship case?
Well, potentially, you've got sort of I'll break it down into like a non-financial and a financial aspect of this. So the non-financial aspect of this would be at some point, um, Tim Jr. or not Tim Jr. The minor child is going to ask questions about where are my parents, and if he finds out the guardian played a role in his mother's death, who knows how he's going to accept that information or potentially resent the guardian for that. So those are sort of the non-financial aspect of it. But from a financial viewpoint, one of the things the guardian has to do, the guardian is going to be acting as a fiduciary for the minor child, which means the fiduciary in the form of the guardian has to make a determination as to what the minor's assets are. One of the minor's assets is a potential wrongful death claim against anybody who contributed to his mother's death. So in these circumstances, you've got the girlfriend wearing the hat of potentially being on the receiving end of a wrongful death claim and the guardian that would have to bring the claim. So she's going to have to investigate herself, essentially, is the short answer of that. So,
As if.
right. I mean, so
It's not going to happen.
There's a financial reason that she should be recused from even considering this guardianship.
So who should protect those claims if the adult seeking custody may also be the witnesses, beneficiaries, or interested parties? Then she can investigate herself. Who should do it?
Right. So these are the things the court should take into consideration at the June hearing. Is it in the minor's best interest to have her appointed as the guardian when she could potentially be subject to criminal claims as well as a wrongful death claim from the minor child? I mean, I think anybody with an objective perspective would say, no, that's not even possible.
Right. Okay. Well, this isn't just about being cruel to any adult, Chris, especially somebody in grief. This is really about fiduciary duty. And when a child loses both parents, I guess transparency cannot be optional, and you can't leave it up to the last person standing to investigate themselves. And the courts need to do better due diligence and interpret the statutes more honestly at this point, instead of playing DEI woke politics, as it looks like in this particular case. So I want to move forward a little bit here. I want to talk about what happened to you. American Maids, we put out in January, a press release on January 6th, and it basically spells out and it questions, it regards questions that emerged after your suspension. Your bar license was suspended. And in the press release, we describe you as a very key legal strategist for American Made Foundation and American Made Action amid litigation and public exposure of CPS and family court corruption. And in our press release, we talk about the fact that there's disciplinary action that came forward as American Made expanded its federal legal campaign against agency overreach, state-sanctioned child removal, and constitutional violations. And it raises concerns about the timing, severity, and possible retaliation. So this is pretty significant what happened to you, because you have been doing the work in family law that you really cherish and you put forward above all else, all the other law that you've done in the past, because you understand the significance of the family. You and I agree. You can't make America great if the families aren't great. And right now, families are literally under attack. So break down a little bit for our audience. What happened to your license and what were you working on when the disciplinary action occurred?
So I had brought suit against the state of New Hampshire and some other agencies in a federal case for the New Hampshire Nine, which are 9 people who, I'll give you the short version of the story. There were just 9 people who were arrested at a governor's meeting regarding the state taking COVID money. This is back during COVID. But they had a question as to when we take the money, what are we agreeing to? And they actually read the proposal. And in order to take the COVID funds, we were agreeing to have COVID camps here. So they were going to the governor's meeting to essentially say, what does this mean? Like, who sets up the camps? How do you end up in them? How do you get out? Like, what does any of this mean? We're going to take this money in exchange for having COVID camps here. And the way the governorship here is set up, the governor is one of the weakest governors. There's an executive council that kind of makes the decisions based on input from the governor. But at these meetings, there's a public comment forum. They went the first time, and it sort of devolved into chaos, and there was sort of a riot that broke out. It had nothing to do with them, but it got tabled until the next month, and it came up again, and it became obvious when they got there, well, because of the last meeting, the public forum section was roped off. You couldn't access it. Only if you were pre-approved to speak could you get access to the podium to ask any questions or make any comments. So they had to come up with a plan B. We can't comment, so what are we going to do? So they decided to silently protest when the governor got up and made his pitch to the executive council that we should accept these funds. The 9 individuals said, we're going to stand up and turn our back to show our displeasure. And that's exactly what they did. And they were all ultimately arrested and charged with disorderly conduct, interrupting a government meeting. There were a couple other charges as well. But all they did, no one disrupted anything. They didn't shout. They just stood up, turned their back, and they ended up getting arrested for it.
Yeah. So much for your freedom of speech, right? So
right. So in that going, I had a couple other cases involving suits against police departments. So you can only
go ahead.
You can only kick the beehive so many times before the state puts you in the crosshays. When you try to mess with the system messes with you.
That's the point. And so to this thing, it's a closed loop system. Family law, well, frankly, a lot of law. Bar card attorneys are they swear an oath to the bar over and above even the Constitution. I mean, their allegiance, and they prove it out in this case point with you, where you are actually calling the system out for the egregious behaviors of the system and what they do in terms of these family law cases and other cases for that matter. But it's a big club, and we ain't in it. And now you're not in it. So this has deprived you and your clients. I mean, this really put a lot of chaos into your life for a period of time, because you had a lot of cases where you're getting $60 an hour compared to these other firms that are 500, 600,000, $1,500 an hour and more. I mean, that's the kind of work you were doing, and they're depriving you and your clients. So of lawful representation, what evidence or arguments were you prevented from presenting in any of these cases?
In my case?
Yeah.
Oh, I mean, I didn't get any notice in my cases. They sent stuff to me via mail, and for whatever reason, the post office returned it. So I didn't even know hearings were happening, and they were just moving forward anyways, despite the fact they were getting the mail back. It wasn't coming to me. The post office was sending the mail back to the sender. So the sender knew I did not get any notice of these hearings, and they moved forward anyways and defaulted me.
Incredible. Absolutely incredible. All right. So let's talk about the timing then, as it relates to American-made actions, cases with respect to CPS and the family court litigation strategy that we have been working on for the better part of a year. How does the targeting of you affect families who are counting on us moving forward with this litigation? And what have we had to do?
So we've had to attract other attorneys. I can sort of help out in a supporting role, but without a license, I can't, give legal advice, or certainly can't go to court.
Sure.
So we've had to recruit other people to be point, to use your phrase on it, which
Hmm.
sort of sets us back. It's more complicated. It's more time consuming. It requires more resources. So it's definitely thrown hurdles up for us to proceed. Um, so
Well, what does
it's
this
made
tell
it
other
more.
lawyers? What does this tell other lawyers who want to challenge the CPS system, family courts, or frankly, the system in general?
Well, right. Sort of. There's always a secondary or a tertiary level of analysis. The secondary level is, you know, think twice before you try to buck the system,
Right.
because you might
Are there
not like the
remedies
outcome.
available? Are there remedies available to you now?
So we're working on vacating some of the stuff that was done previously, but I mean, you, we all know how time consuming the courts are. So it's just, we're working on it, but it's just a matter of time.
Right, and that's just it. They're trying to run the clock out. They want to make sure that they deprive you of being able to earn an honest living to help good people, many of whom been in this chat probably, because they understand just how desperate the situation gets when they have an attorney like yourself who will go to the mattresses for them and then get sidelined. They're going to try and wait the clock out in hopes that you have to go flip hamburgers at McDonald's just to make ends meet, essentially. I mean, this is just how diabolical they are. What do you want the public to understand about attorney disciplinary systems?
So again, it's much like, the family court. It's
Right.
an accusation that may or may not be supported by evidence. There's a lot of hearsay that comes in. There's a lot of allegations, and there's a lot of things that get based on emotion. Um, make sure don't come to some sort of preconceived conclusion just because there's an accusation made.
Right. All right. Well, apparently, when attorneys can be sidelined while constitutional litigation is escalating, it doesn't just become about one lawyer. Apparently, it becomes a warning to every family seeking counsel and every lawyer considering whether to take a case. Enter the United Law Coalition. This is why American Made Action launched the United Law Coalition. The United Law Coalition is described as a national call to legal experts, lawyers, paralegals, law firms, and lawful experts to help build cases, organize evidence, achieve archives, draft filings, pursue remedies, defend constitutional rights, and hold powerful actors accountable. So, Chris, you are the head of the United Law Coalition. Give us, from your perspective, the 50,000-foot flyby. What is the ULC?
So it's an organization of, like you had said, from A to Z, top to bottom, lawyers, paralegals, everything you need to move your case forward in whatever jurisdiction you find yourself. There's a screening process. We're looking for cases to sort of change things, change policies. We've got some cases in the works. Um, and if you think you've been wronged, reach out to us. There's a screening process. Somebody will get back to you, hopefully. But once you have one or two of these cases, it's like the floodgates opening, and you would be amazed at the number of calls and issues that get floated across my desk every day.
I know about a few of them, Chris, only because Maureen and I are in constant contact with you. Why does America need a national legal coalition instead of isolated families fighting alone? What can that leverage get them?
Well, it reminds everybody, including the courts, this is not a one-off. I mean, when you walk into a court and you've got one plaintiff in a case where the judge knows this is a sealed file, so whatever happens in this courtroom isn't going beyond this courtroom. That's a totally different scenario than going to, a federal court that has 6 or 7 litigants spread across multiple jurisdictions, a few different states. Now it's not a one-off. Now it's much more media worthy. they're way more attentive and way more willing to apply the technical rules of evidence to make sure everybody's treated fairly and things don't get based on emotion. So
Right.
we're back to transparency, the one thing that these courts all lack.
Clearly. What kind of cases is ULC looking for?
So right now we're looking at cases involving Child Protective Services. We've got some cases where abuse of guardianships or incapacitated persons. Again, we weren't looking for this, but this sort of pattern popped up that probate courts are declaring people are incapacitated. Now somebody else is making decisions for your elderly relatives, not you, not a family member, somebody appointed by the court because the court decided at a 15-minute hearing, well, you're incapacitated, you can't make decisions for yourself, so the court will get somebody to make your own decisions.
Right.
Now you can't even leave Florida. Let's say you're in Florida and I'm just making this up, but let's say you go to Florida for the winter. You're down there because you have a second home, and the state of Florida decides you're incapacitated. Now somebody else is deciding whether or not you can go back to where you came from for the winter.
What evidence should the families preserve, and what kind of attorneys and paralegals are needed to review the evidence that families have preserved? Because this is a team effort under the United Law Coalition.
So document everything. Do it in writing. Phone calls are not preferred because you can't document a phone call. Even when you interact with an organization like Child Protective Services, they have these call logs. But the call log is the caseworker writing down what they think you said. So they're essentially making their own record. So whatever, I've seen call logs of calls I've had with the caseworker that look nothing like the actual call that I had with the caseworker.
Wow.
So do everything in writing, if at all possible, and make sure it's in pleadings, because if somebody else takes the case over, another judge is on your case, the first place the judge is going to go is the pleading sections in the court file.
Okay.
So make sure the important stuff is in the pleadings.
Okay. I'm going to move into the rapid fire questions here. One thing every parent should document immediately when CPS appears.
Why they're there and what documentation they have.
Okay. What's one mistake families make in family court?
Thinking that you have to do what the caseworker tells you to do.
Ooh. What's one thing judges need to be held accountable for?
Making sure everybody's treated fairly. Like, don't assume the caseworkers are right.
What's one reform you would make tomorrow?
Well, I think the biggest reform is making judges electable.
There you go. Name one good reason lawyers avoid these cases.
Because it's not worth the headache of the reduced hourly fee that you get.
Oh, wow. Okay. What's one reason they must stop avoiding them?
I'm sorry, repeat the question.
What's one reason these lawyers must stop avoiding these cases?
Oh, well, if Child Protective Services, think about it this way. If Child Protective Services made an accusation against you as an attorney, you would be grateful there was someone like me who's willing to make the reduced hourly rate to help you out. So
sure.
Keep that in mind and take a couple of these cases.
What does best interest of the child really require?
Well, I think best interest of the child, it's such an amorphous concept. So some states have statutes which outline, 5 or 6 things, elements that they have to go through. But
sure.
One of the things that has to be considered is best interest is being with family. Like I can't tell you how many times the court will say, well, we're going to put the child in placement because he doesn't really have a relationship with dad. He doesn't know dad. So we're going to put him with this foster family who he doesn't know. Like, the logic only makes sense to a bureaucrat.
You said it from your lips to their ears. Chris, last question. What gives you hope?
The fact that there's people out there like me, you, Maureen, and the people watching who know this is wrong, and no matter how many times it happens, won't give up and won't roll over and play dead.
That's right. I mean, you're looking at a suspended license. You're being represented by Peter Tickton in the Supreme Court in New Hampshire. That case is yet to be scheduled. Is that right?
Yeah, we're still waiting.
Right. Of course, they're just making scheduling sort of like out there nebulously in the future sometime when they could frankly have a hearing really rather immediately. But this is the games in which they play, and you are still in it to win it. And you're here because you believe in the sanctity of the family. It's our fundamental right to raise our children. For whatever that's worth, it is still our fundamental right. Chris Burns, the director of the United Law Coalition, a director at American Made Foundation and American Made Action. It is an honor to work with you, and I appreciate you taking the time to help educate the public today and hopefully instill some hope in folks out there. Give them some good ideas of what they should and shouldn't do. And, we're all in this together. So this is how we govern. We govern ourselves, and the bureaucrats are supposed to listen to us. Frankly, we need to just get rid of them. So God bless you. Thank you for being here.
Thank you, Ann.
All right. Wow. Well, that was a very enlightening interview, I think, for some that have not been fully up to speed on what goes on with Child Protective Services, family law courts. But you've now gotten a little look into what American Made Action is doing and our United Law Coalition, in which Chris Burns, who is an incredible attorney, is very, very brilliant, is facing his own legal challenges because they've decided to suspend his bar license because they don't like the fact that he's challenging the system. How can you stay informed? Well, pick up a copy of this book, CPS Pipeline State Sanctioned Kidnapping. It has got, as you'll see here, it is not a very thick book. It doesn't have scratch and sniffer pictures, guys, but it is very concise and to the point, and it has a bonus chapter, chapter 11, written by KL, who joins us from time to time and puts out incredible content on trusts and wills and estate planning, et cetera, how to circumvent the jurisdiction. But this book is very, very, very valuable. General Michael Flynn wrote the foreword to the book, and I think you all should pick up a copy and get yourself educated. All the money goes to the foundation in terms of funding litigation, because we've got to work with other attorneys, and they do work for a reduced rate, but we still have to pay them. That's how it works. So today's conversation isn't just about one attorney, one grandfather, one child, or one case. It's about a system that can take a family tragedy and turn it into a court-controlled proceeding where the people closest to the child have to fight just to be heard. A system that can take a biological grandfather and force him to prove he is standing after his grandson has lost both parents. Imagine having to prove you have standing to get your biological baby. Unbelievable. A system that can take a mother's death, a father's death, a child's grief, public fundraising, competing petitions, disputed authority, and sealed proceedings, and then ask the public to simply trust the process, trust the plan. 2 weeks to slow the spread. I mean, we've heard this. We've been there before. Have we not learned a lot since COVID? I don't trust a process that hides from scrutiny. I don't trust a process that treats grandparents like strangers. And I do not trust a process that silences parents, disciplines dissenting attorneys, and calls it justice. The Macklin case matters because Emerson Sonny Macklin matters. He's not a symbol. He's not a fundraising line item. He's not a political prop. He's a child. He has a name. He has blood running through his veins. He has family. He has a grandfather asking to be heard. And the Rivera case matters because 5 children matter. Their mother and father matter. Due process for all matters. How many cases of due process were blown straight out to smithereens during J6? You see, the playbook is the same. But Christopher Burns, who you saw here today, his case matters because when lawyers who challenge CPS, DCF, and family courts are sidelined, the families they represent are also sidelined. That's why American Made Action and the United Law Coalition matter. We're not building outrage for entertainment. We're building an infrastructure for accountability. And the United Law Coalition exists to bring together attorneys, paralegals, researchers, lawful experts, whistleblowers, and citizens who understand that constitutional rights don't defend themselves. Families cannot fight billion-dollar systems alone. Children cannot file motions for themselves, and parents cannot expose sealed corruption without help. And good attorneys cannot stand alone while disciplinary systems are weaponized against them. American Made Action is doing the work. We're gathering the evidence. We're supporting litigation, exposing abuses. We're building legal teams, and we're forcing these stories into the public eye. So I've got a call to action for you. Support the work, share the cases, send evidence. Go to our website, AmericanMadeAction.org, on the screen. You can upload your cases and take what Chris Burns said to heart. Keep all of your evidence. Track everything. Join our coalition if you're an attorney and you want to help. And then you can also help fund the legal fight, help build the archive, help protect families who are being crushed in silence. Because if we don't stand now, the next family may be yours. And if the courts can decide who gets your child without truth, transparency, and due process, then we do not have justice. We have authoritarian control. I'm Ann Vandersteel, and this was Steel News. Stay loud, stay free, and never stop fighting for the children. Have a blessed day, everybody. Thanks for joining.
Food security or food sovereignty. Every time we buy food, we choose. Glyphosate exposure is exploding, and people are asking, why is food so expensive? This is why we do what we do. Organic fields, thriving orchards, the purest ingredients straight from the earth. From our farms to your family, we do the testing so you don't have to. You save time, you save money, and our regenerative farms continue to grow. It's time to remove what does not belong. Rebuild with cleaner inputs. Support the farmers with the future in mind. This isn't a trend, it's a shift. We still have a voice. We still have a choice to vote with our dollars for a healthier America today. Tap the link.
Are you ready to take your health back? At VandersteelHealth.com, I trust Purium's powerful superfoods to fuel my body with clean, plant-based nutrition. And in a world filled with toxins, Biomedic is designed to help support your body's natural detox process, even from glyphosate exposure. Real nutrition, targeted support, no junk. Go to VandersteelHealth.com and take control of your health today.